So it'll be the same rules that we always have when we're in the actual physical courtroom, and that is each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes.
Okay.
It will be broadcast on YouTube, so please don't mention victims' names or children's names. All right, thank you.
Thank you. May it please the court, I'm Jacqueline Corrigan on behalf of the state, which in this case is the appellant, urging this court to reverse the decision of the trial court to grant Mr. Roper a new trial. And I would like to reserve 5 minutes of my time for rebuttal. And as far as the facts of the case, this court has already seen the facts because it has already affirmed Mr. Roper's conviction and sentence in his underlying direct appeal. But Mr. Roper successfully moved for a new trial because one of the jurors in his case was found a few years later to have failed to raise her hand when the entire veneer panel was asked if anyone had had any previous involvement with Summit County Children's Services. And the state submits that the trial court's decision to grant Mr. Roper a new trial on that basis, that was an abuse of the trial court's discretion because basically for two reasons. Because contrary to established case law, the trial court granted Mr. Roper a new trial despite making no actual finding that the juror had been deliberately dishonest when she failed to raise her hand. And also because the trial court granted Mr. Roper that new trial without actually analyzing whether a truthful response by that juror would have been grounds for Mr. Roper to have had a challenge for a for-cause challenge for that juror. You know, irrespective of the court's opinions of juror number 4. And this was contrary to the case law authority that we've laid out, all of us have laid out in the briefs in Grundy versus Dillon, which held that you need both a deliberate failure by the potential juror or the juror to have honestly answered a material question during voir dire, and you have to have the showing of prejudice, meaning that an accurate response by the juror would have been valid grounds for a for-cause challenge of that juror. And that for-cause challenge, that must have been on behalf of the movement. There must have been grounds for the for-cause challenge by the movement, not for the other party. And that's made clear by Grundy, not necessarily in the holding, but in the explanation that the court gave for why it determined that the trial court in Trumbull County dealing with a medical malpractice case had correctly denied the plaintiff's motion for a new trial.
Counsel, the crux of the argument here seems to be that the second part of the test, that the trial court, that the attorney didn't have to actually show good cause or cause for removal, but just had to have grounds, didn't have to actually prove it.
Well, there is a case, and it's cited in the brief. We've called it Stevens 1, where the 5th District said that there had to be not just grounds, but it had to have been something that would have been successful, a successful challenge for cause. But in this case, the actual party that had grounds or potentially could have had grounds to make a for-cause challenge against juror number 4 wasn't Mr. Roper, it was the state, because juror number 4 was essentially the ideal juror for Mr. Roper, but was not a juror that the state would have wanted. But I was going to talk about why that's true from Grundy versus Dillon, because it's a case that illustrates why it has to be, grounds for the movement to bring the for-cause challenge. Again, Grundy was a medical malpractice case out of Trumbull County dealing with an emergency room visit at Trumbull Memorial Hospital. The the panel in that case was asked whether any one of the potential jurors or any of their family members had had treatment at Trumbull Memorial Hospital's emergency room, and whether they had any kinds of, whether the jurors had any low opinions or even high opinions of TMH's care based upon that. And the juror in Grundy his son had visited Trumbull Memorial's emergency room, and the juror was displeased with the standard of care that his son had received, did not disclose that when he was asked about that. And when the trial court denied the motion for a new trial, the trial court noted that the party that would have had the challenge for cause for that juror would have been Trumbull Memorial Hospital, not the plaintiff. And the case had resulted, of course, in a defense verdict for Trumbull Memorial Hospital, and the Supreme Court agreed with the trial court's reasoning in addition to setting out the two-part test that we're dealing with. So it shows that the actual prejudice that has to be suffered by the moving party has to be that there would have been a grounds for a challenge for cause by that party, not necessarily a generic basis for a challenge for cause by somebody, which is basically what happened in this case. Was that the trial court, even though the trial court never found that this juror in question had deliberately failed to honestly answer the question, has anybody had a family, had family involvement with CSB, there's no finding that she was deliberately dishonest, but the court then said that there could have been grounds for a challenge for cause, but never delineated which party could have had that grounds for a challenge for cause. And as you can see from our briefs, the state's position is that it was the state, not Mr. Roper, who would have had that challenge. But you do have to have both prongs. You have to have that finding of deliberate failure to answer dishonestly, and also the prejudice prong. And you can't infer any bias on the part of the potential juror or the juror without a deliberate falsehood. That's the case from effective shareholders from the 1st District and State versus Necessary from the 11th District. Again, I also touched on Stevens 1, which found that you not only have to have a valid grounds for a challenge for cause, but it needs to have been successful. And keeping in mind that partiality, dealing with State versus Necessary and effective shareholders, if a juror can be impartial, the weight of authority is that you have no grounds to remove that juror. That's from this court too in State versus Valega. And without having a deliberate falsehood, the court should not have even moved on to determine whether there was prejudice. That's from State versus Wygand. So the court in this case never found a deliberate falsehood by this juror. Instead, twice the court says that the juror did not, quote, fully participate in voir dire. That's not enough. There has to have been deliberate deception. There was no finding that this juror was deliberate in not raising her hand. Instead, the trial court criticized her statements as being arguably absurd, but that doesn't sink to the level of deliberate falsehood.
Counsel, I neglected to ask you, do you want to say 5 minutes or?
Oh, yes, I did. I think I had said that at the top.
No, you probably did, and I didn't catch it, so I apologize. Okay, that's fine. You're at the 5-minute mark now if you want to wait.
I will reserve the rest of my time for rebuttal then. Thank you.
Thank you. Mm-hmm. All right, you, counsel for Applee, you have 15 minutes to present your argument.
Cover 3 big picture items and then 3 more kind of details and specifics.
I'm having a hard time hearing you. Are the panelist and the other attorney hearing okay? Or
You can't hear? Is that
I
help?
can, yes, a little bit, but then we can't see your face.
Okay. Here, I don't know how to fix it. Can you hear me at all?
I can hear you. I don't want, let me just double check. Can the other judges hear him?
I can hear him when I cannot see his face.
Okay.
Bending down means we cannot see your face.
Move the camera down, Aaron, so I can just. Where would you like about how far? All I wanted to do, can it just pivot down so that they can see my face when I'm hunched over?
I was gonna say, sit down, counsel. That's fine. Sit down. There you go.
Okay. Does this work?
A little better.
It's a
Okay.
little better.
I get a pretty good echo, so that'll be a fun experience.
Yeah, I'm hearing the echo too. I'm sorry.
Okay. Well, we're all doing the best we can.
That's right.
I have 3 big picture points. The first is that, as this court well knows, this case is governed by the abuse of discretion standard. The abuse of discretion standard is intentionally very difficult to surmount. It requires more than an error of law or judgment. It means that the court was unreasonable, arbitrary, or unconscionable. And an appellate court cannot substitute its judgment for the trial court, even if it doesn't find.
Counsel, I think you muted yourself. There we go.
Yeah. Again, an appellate court has to, cannot substitute its own judgment, even if it wouldn't reach the same result, and even if it's less persuaded by the rationale. The second big picture point at play here, permeating the entire case, is that this judge was incomparably qualified to rule on the new trial motion. She oversaw the entirety of the proceedings, including voir dire, jury trial, and all of the new trial motion litigation. If the court looks at pages 67 to 70 of the new hearing trial transcript, the court forcefully reminds Juror 4 that she's under oath. That is an indicator of just how firm the judge was in finding dishonesty here. Admittedly, the judge uses very deferential and respectful language to Juror 4 in the entry, but that doesn't demonstrate that she's incorrect, let alone that she's unreasonable, arbitrary, or unconscionable. And the third big
But counsel, you do have to make that first finding, right? That the juror was deliberately dishonest.
She did make that finding.
We're in the entry, does she? Sounds like she's just saying that she was mistaken.
If we look at page 2, she speaks to, and this is the state's big point, that she didn't make a dishonesty finding. That's cabined to her responses on her marital status and her son's criminal history. From page 2 on, she's describing the entire time Juror 4's dishonesty, and she's describing how that prejudiced Mr. Roper. She may be using language that is respectful, that is not purposefully going after someone, a citizen of Ohio, but it demonstrates clearly that she finds a dishonesty answer. There's a couple of reasons we know that. One, she's identified the correct legal standard. Everyone involved has identified Grundy as the legal standard. She could not come to the conclusion that she came to under Grundy without making the dishonesty finding. But if we look at the entry, there's a number of places where she identifies dishonesty. If we go to top of page 4 of the entry, on page 3, she lists the stipulation. The stipulation alone demonstrates that Juror 4 was dishonest. The questions during voir dire were, does anyone have a family member who's been a victim of abuse? Has anyone had dealings with children's services? Is there anything else I should know? The prosecutor in Juror 4's former husband's trial, on cross-examination, put it to her that she was dishonest. So much
Counsel, when the question was asked of the juror, of all the jury other than Ari, has anybody had a family member that was a victim of sexual abuse? Why didn't she, I mean, it could be construed that she answered honestly when she didn't raise her hand or didn't say, I have, because she didn't feel that her daughter was actually abused.
Well, okay, let's say she genuinely did not believe her daughter was abused. What she knew at that time was that Children's Services was involved, and later I will detail in litany all the extensive dealings with Children's Services. And she knows that the Children's Services conclusion, as documented in the report at page 29 and 31, was that abuse was substantiated. So an honest answer there would not be no. It would be, well, my daughter made an allegation, Children's Services did an investigation, Children's Services said it was substantiated, but I don't believe my daughter. That's the kind of information that defense counsel has to know to be able to probe further. And also, it's sufficient on its own, but there's a litany of other things here that would create a valid basis for a for-cause challenge there. The state's creation that Juror 4 is an ideal juror for Mr. Roper is inaccurate. It's too simplistic. We cannot predict what someone who has gone through the complex dynamic of a sexual abuse situation in their family, how they would apply that to others. And you combine on top of that, that complex emotional, visceral dynamic within a human being. She can't speak about this event accurately. She can't speak about it honestly. You combine all of that together, and there's no doubt that a defense attorney, at minimum, would reasonably move for cause. And as this defense attorney, Brian Pierce, who this court may know better than I, but I believe he untimely passed away late last year. And at that time, it was demonstrated that he had a very strong reputation in the Summit County legal community. He testified without doubt, if I knew these things, if I knew this full picture, I would move for cause and I would expect the court to grant it. And the trial court, I believe it's page 9 of its entry, says that Brian Pierce's testimony is compelling. So another piece here is, because everyone has identified Grundy as the proper legal standard, and because we have an abuse of discretion standard, and because there is great deference given to judges who have overseen the entirety of the proceedings and have been able to see the people in their courtroom and judge credibility, at best, in the state's situation, we have a situation where there's fair-minded disagreement. We think the entry is explicit on finding dishonesty and prejudice. The state thinks there's not a finding of dishonesty and that there is not a finding of prejudice. That's fair-minded disagreement. The trial court and the defense see it one way, the state sees it another. Anytime there's room for fair-minded disagreement, by definition, you cannot have an abuse of discretion. Because an abuse of discretion is unreasonable. It's arbitrary. It's unconscionable. No objective review of the totality of this case and the entirety of the language in this entry would result in a conclusion that the trial court acted unreasonably, arbitrarily, or unconscionably. I'd like to look at the details of Juror 4 and how she would appear to defense counsel if she had answered honestly We already covered the piece regarding her sexual abuse in her family. But the big one here, which is disclosed and identified later by the turning over the Children's Services record, Juror 4 did not raise her hand, thereby answering no to whether she had had any dealings with Children's Services. Her dealings with Children's Services were extensive. We've already identified the substantiated claim of abuse against her daughter. But she stated there was no open Children's Services case file at the new trial hearing. The Children's Services records demonstrate there's a case file open in her name. The case number is 1663140, and it's 46 pages long. Again, going to pages 67 to 70 of the new hearing trial, the trial judge on the spot, even though she doesn't have the benefit of the Children's Services records, says, I want to remind you that you are under oath, because she already found it incredible. Juror 4 can only speak in an incredible way regarding her family, sexual abuse history, and her own involvement with Children's Services. The Children's Services records also make clear that Juror 4 and her then husband, who was the man that was convicted of raping her daughter down the road, had a sit-down meeting with Children's Services in which at least some component of the details of the investigation were discussed, and the man accused made statements claiming his innocence. Juror 4, both at voir dire and at the new trial hearing, said that she didn't have extensive dealings with Children's Services. She said, I talked to him. But she sat down with her husband, or then husband, with Children's Services. She claimed that, again, she only had a little bit of contact. There are documented calls throughout the Children's Services records, and they're documented in such a way that she's asking, where will my daughter be placed? She claimed at the new trial hearing that she had no idea Children's Services was involved in the removal of her daughter, that it was only the police. Again, the Children's Service records blow that out of the water. There was a safety plan in place with Children's Services for Juror 4 that Juror 4 was aware of. She stated at the new trial hearing, I did not have supervised visits with my daughter. Children's Services records document not only a supervised visit, but a supervised visit so closely that the Children's Services observer was able to write down what was being talked about. If my memory is correct, it's something about a boyfriend or something to the, but if you look at the Children's Services records, it makes clear that at least one visit was supervised.
Counsel, don't all these facts that you're reading off really go to whether she was dishonest and not really to whether she could be removed for cause? Because if she had answered honestly that she had had involvement with CSB, you wouldn't have had all those records. You would have just had somebody saying, yeah, that she had been involved in CSB. There probably would have been a sidebar, and she would have been able to explain a little bit more about it, so it wouldn't have been in open court, but you wouldn't have had all that information.
Well, her question, for one, as Grundy demonstrates, when we're in a new trial litigation, you have to look at the totality of the evidence within the record. So we do have to evaluate with that after the fact Children's Services knowledge. Even if not, one, she's not being honest. So let's say she gave a watered down answer on Children's Services and said, yeah, I think maybe they watched one visit or something, but it was insignificant. That, if you go to Attorney Pierce's testimony, he states that's a concern for him. And that is a concern at a level that is going to give him a valid basis to make a for-cause challenge, and he would expect the court to grant it. The trial court in the entry again at page 9 says such testimony was compelling. And it's compelling for a number of reasons. She states, this conclusion is further supported by the hearing testimony of Mr. Pierce, who is trial counsel concerning specific voir dire practices and procedures he had developed throughout the course of his career as a criminal defense lawyer. Such testimony was compelling. Attorney Pierce is telling the court at the new trial motion, in my heart of hearts, I know that I would have moved for cause for this juror. That meets the Grundy standard. And objectively, this record supports that. The trial court's conclusion on that is unerring. Even if it is somehow in error, it's not arbitrary, unconscionable, or unreasonable. She's identified the correct standard. She's applying it to this case. Again, no objective review could result in that being an abuse of discretion.
Counsel,
Yes.
I'm just looking at your time, and your time is up.
Okay.
Thank you. Thank you for your presentation. And the state will have 5 minutes for rebuttal.
Thank you, now that I've turned my mic back on. I would take issue starting with a couple of things. First of all, Judge Carr, you were absolutely right in noting that there was no explicit finding by the trial court that this juror was actually dishonest, and not even in any of the language after the court's finding concerning the marital relationship or the juror's son's criminal record past page 2. Not an explicit finding that she was actually dishonest. The only thing the trial court said at 2 places was that she did not fully participate in voir dire. That's not the standard. It is an abuse of discretion, by the way, to note what the correct standard is that one must apply as a judge, and then not to actually follow it in application. And as to what kind of the question of what did everybody in this case know and when did they know it, kind of so an analogy similar to that. When we're looking at whether there was a valid ground for a challenge for cause, you have to look at whether an honest answer to the question would provide a ground for a valid for-cause challenge. Not what you learned later about the juror, but whether that honest answer to that question would have provided the grounds for a valid for-cause challenge. In this case, an honest answer that CSB had been involved in juror number 4's family would not necessarily have been a valid ground to excuse her as a juror. Instead, everything that counsel discussed about CSB's records, and Judge Carr, you're absolutely right, none of those records mean that Mr. Roper would have had a valid for-cause challenge to this juror. All it indicates is that this juror had involvement with children's services. It also doesn't mean that she would not still have been a juror who might even potentially be biased in Mr. Roper's favor, because when you look at all of the evidence here of what she might have talked about if she had been asked further questions about her CSB involvement, okay, they didn't have an open case at juvenile court regarding this juror's child at the time when Mr. Roper's trial was going on. But even if she sat down with CSB at a previous point, she believed the recantation of her child. When she did not believe her child had been abused, she instead chose to believe her child's recantation. It was after Mr. Roper's trial that her child then recanted the recantation, and additional children came forward to accuse juror number 4's husband of similar abuse. When it came down to the hearing in this case, that juror actually testified that not only did she still not believe her own child in the wake of her husband's conviction, but she also did not believe any of the other children. Now, granted, that's after the fact, okay? But at the time when Mr. Roper's voir dire was occurring. The fact that she would choose to disbelieve her own child, in a sexual abuse accusation would have made her subject to a valid challenge for cause by the state. Because if any person that does not believe their own child could be presumed not to be amenable to believing other children in similar types of cases. So there is no showing that an honest answer to that question, have you had any involvement with CSB, would have de facto led to this lady being removed for cause on a motion by Mr. Roper.
Counsel,
Yes.
your 5 minutes is up.
Well, I thank you very much and urge you to reverse. Thank you.
Thank you. Thank you for both attorneys appearing, and sorry that we had to have you sit so close to the microphone, but it turned out well, and you got to sit down too. So anyway, so we'll take the matter under advisement, and we'll issue a written opinion that will be sent to both sides, and we also release on our website as well, as you know. So try to have a good day.